Welcome to the deep dive. Today, we're tackling something pretty hefty. We're not just looking at one topic, but really the whole underlying structure of ancient society, specifically its justice systems.
That's right. We've got a real mix of sources here. Gaius, Justinian, Demosthenes, Cicero, Grote, Bury. It's quite a stack.
And our goal, our mission, if you like, is pretty ambitious. We want to understand how Greece and Rome, these two, giants of antiquity, actually built and operated their legal systems.
And crucially, how those systems responded or maybe bent when they came up against things like political power, social rank, and, well, sheer military force.
It's about the machinery of law, isn't it? How it actually functioned on the ground.
Exactly. We're digging into the mechanisms. How did Athens manage control without, say, a modern police force? When does justice start looking a lot like vengeance?
Right, and that gap between the law on paper or maybe on a stone tablet and how this really applied. Especially in Rome, it seems like your social standing was almost everything.
It really shaped the outcome. So yeah, these sources, they give us this incredibly rich, sometimes conflicting picture. It's fragmented, sure, but it tells us a lot about where power really was, and sometimes it's not a pretty picture.
Okay, let's start unpacking that. Maybe begin in Athens, classical Athens. We often think of philosophers, democracy.
Yeah.
But the reality of Athenian society was, well, quite competitive, wasn't it?
Fundamentally agonistic. That's the key term. Competition was everything.
Everywhere, not just in sports.
Oh, absolutely. It permeated civic life. And the courts, they were definitely part of that. Yeah, we talk a lot about Athenian juries, democratic ideals, but you really have to see their litigation, their court cases, as often being just another form of feuding. It was an extension of existing rivalries.
Fighting for honor.
Precisely. Philotimia. That pursuit of honor, of public recognition and standing was absolutely core to being a citizen. It's what separated you, supposedly, from animals. You had to compete, you had to respond if wronged.
And the courts were just another place to do that, a more formal arena.
The most prestigious, regulated arena for that competition. If someone slighted you or owed you money or trespassed, going to court wasn't just about getting a legal ruling. It was about winning publicly, shaming your opponent.
And the sources give us that amazing long-running feud between Demosthenes and Medius as a prime example, right? It wasn't just the famous slap in the theater.
Not at all. That was just one flashpoint. The whole thing went back years, starting with Demosthenes trying to recover his inheritance, his patrimony.
And that initial dispute just snowballed.
Completely. It's a textbook case of Athenian feuding. It pulled in relatives, friends, supporters on both sides. Action, reaction, counteraction. Demosthenes actually won a case at one point, proving he'd been unjustly deprived of his inheritance.
You got a verdict.
He did. The court agreed with him. But here's the kicker, the real insight into how Athens worked.
Winning didn't mean he got the money.
Not necessarily. Winning the case, proving the legal point, getting that public validation, that was huge. But it didn't automatically mean the underlying dispute was settled, or that the cash actually changed hands.
So the court was more about assigning blame and restoring honor publicly.
Largely, yes. It wasn't this clean, efficient machine for financial resolution like we might expect today. It was social and political combat.
Which really highlights that central contradiction in Athens.
Exactly. You have this formal political equality. Every citizen can technically speak in the assembly, serve on a jury. They're brought together as equals in that sense.
In reality.
They were anything but equal. You had incredibly wealthy, influential figures like Medius rubbing shoulders in court with people of much more modest means, maybe skilled speakers like Demosthenes, but without the same resources.
And that economic and social gap must have affected everything. How they argued, how the jury saw them.
Absolutely. It colored the whole presentation. How you framed the conflict, how evidence was perceived, what winning even meant. It was about public victory, shaming your enemy just as much as, if not more than, the strict legal outcome.
Okay, so if the courts were these competitive arenas for citizens fighting over honor, how did Athens actually handle the basic day-to-day enforcement of norms? Like who kept the peace, what we'd call policing.
Well, that's an interesting thing. They didn't really have a dedicated police force in our sense. It largely fell to individuals, private citizens.
So citizens policed each other.
In a way, yes. Magistrates existed, of course, but they were mostly reactive. They depended heavily on citizens bringing issues to them. The main mechanism was indicus denunciation.
Denunciation. So basically ratting someone out.
Kind of, yeah. A private citizen could denounce someone they believed had broken a law or violated a norm, and then that citizen could even make the arrest themselves and bring the accused to the magistrates.
Wow. So enforcement was really decentralized, almost privatized. Doesn't that sound like a system just waiting to be abused, especially in that feuding culture we just talked about?
It certainly had potential for abuse, no doubt. It relied a lot on, well, citizen initiative and perhaps a degree of social pressure, but there were some stronger controls. For example, if someone was declared atomoi, stripped of their citizen rights.
Like a civic death sentence, almost.
Sort of. If an atomos was caught trying to act like a full citizen, like speaking in the assembly or going to court, then they could be immediately imprisoned by this board of magistrates called the 11 until their trial.
So that was a clear line.
A very clear line, one of the strongest tools they had. But even then, it wasn't automatic jail time for everyone denounced. For many lesser offenses, people might be left free or offer sureties like bail. Pretrial detention wasn't the default for non-capital crimes.
But the key point is, magistrates weren't proactively patrolling and arresting people.
Generally not. They waited for a citizen to initiate the process through denunciation. The onus was on the community itself.
And sometimes, that community initiative, especially for moral issues, could get pretty hands-on, like state-sanctioned vigilantism almost.
There were definitely instances where the community, or rather any citizen, was authorized to inflict immediate punishment or humiliation for specific transgressions.
Such as?
The sources point to the case of an adulteress. If she defied social norms by, say, attending public sacrifices or wearing fine adornments in public, anyone had the right to punish her on the spot.
Anyone. What kind of punishment?
It could include beating Tiptine, tearing her clothes, basically public humiliation. The only limits were they couldn't kill or permanently maim her. The goal was explicit. Dishonor her, make her life unbearable. The state basically deputized ordinary citizens to enforce that specific social shame.
That's incredibly harsh. Was there anything comparable for men who committed adultery?
Well, the texts do mention parallel punishments for male adulterers. Things like raphinidasis, which supposedly involved radishes being used in a rather unpleasant way, and depilation, ultimate humiliation.
Supposedly. Sounds skeptical.
Well, modern scholars are quite skeptical about how often these extreme physical humiliations actually happened. It's possible, maybe even likely, that the threat was the main thing.
The fact that the law allowed a wronged husband or any citizen to inflict that kind of violence.
Exactly. That authorized threat itself might have been a powerful deterrent, a form of social control, perhaps used far more often than the actual gruesome act itself, the power of potential shame.
This blend of law, vengeance, community enforcement, it feels like it leads naturally into how Athenians thought about justice on a deeper, more philosophical level, maybe through their tragedies. ##C, the problem of contradictory justice. Aeschylus and Orestes.
Absolutely. When you look at something like Aeschylus's Oresteia, you're moving from the rough and tumble street-level justice or court justice to these huge existential questions for the whole community.
It's about that shift, isn't it? From the old cycle of blood feud, endless vengeance.
To a new system. Civic law, mediated by the polis, the city-state, embodied by the goddess Athene herself in the play.
It's like the ultimate origin story for their legal system. And Aeschylus wasn't just retelling the myth, he was twisting it, right?
Right.
Homer saw Orestes, who killed his mother Clytemnestra to avenge his father Agamemnon, as basically a hero.
A noble man, yeah. A model for Telemachus. But Aeschylus, he takes that story and makes it deeply, deeply problematic. He puts Orestes in this impossible situation.
The double bind.
The classic tragic double bind. Orestes has to ask, what am I to do? Because to get back his birthright, his father's throne, his patrimony, he has to kill his mother. He must violate the most sacred bond of the household to reclaim that very household.
An impossible choice. There's no right answer that doesn't involve transgression.
None. And that highlights the limits of human agency, human responsibility when you're caught in this larger cosmic or ancestral pattern.
What's really striking, though, is that even after the trial in Athens, where Athene sets up the Areopagus court and the Furies are calmed down and become protectors of the city, Aeschylus doesn't just give us a simple happy ending civic law solves everything message.
Not at all. The tragic sense persists. Even with the new court, the new order, humans are still shown as kind of trapped by the past. Things are set in motion that they can't control.
So the law can manage the community, but maybe not the individual's fate or the weight of history.
That seems to be the point. The source material notes this grim picture. Human lack of control remains. Even the goddess Athene acknowledges that a person's ruin might come silently, not from their own mistakes, but from the sins of former generations.
Wow. So the formal justice system, the courts, the juries, they impose order on the surface.
They provide a framework, a way to stop the cycle of violence outwardly, but they don't erase that deeper sense of ancestral doom, of inherited consequences. Civic law is layered over this grim reality. It doesn't replace it.
That's a profoundly different way of thinking about law and accountability compared to, well, where we're going next, across the sea to Rome.
A very sharp turn. We're moving from that citizen-driven, honor-obsessed, philosophically fraught Athenian system
To the highly structured, formalized, almost bureaucratic legal world of Rome. #2. The fictions and formalities of Roman law.
It's a huge shift. The focus moves from personal honor and performance to formal roles, precise legal language, established procedures, and central to this, right from the early Republic, is the figure of the praetor.
The praetor. His job was to declare the law, isis rhetor. And the specific role of the praetor urbanus, the city praetor, was created way back in 367 BC. Why then?
Out of sheer necessity, really, it's classic Roman pragmatism. The top magistrates, the consuls, held the ultimate authority, the imperium, but they were almost always busy fighting wars, expanding the empire.
So they couldn't handle the day-to-day legal business in Rome itself.
Exactly. They needed someone to administer justice in the city. Cicero actually mentions that in ancient times, the consuls themselves were sometimes called praetor or iudex judge, so the title had old roots.
But the praetor wasn't equal to the consuls.
No, he held consular powers, but only in an auxiliary capacity. He was seen as the collega minor, the junior colleague. We see this in military situations, too, where a praetor could be subordinated to a consul. He filled that vital administrative and judicial gap left by the consuls being constantly off campaigning.
Okay, but if he was just the junior colleague, how did the praetor's edict, his annual declaration of legal principles, become so incredibly influential? How did it end up shaping Roman law so much, even changing bits of the old civil law? That sounds potentially disruptive.
But that's the cleverness of the Roman system. The praetor didn't technically overturn the ancient civil law, the Nanos Civil. He worked alongside it, supplemented it.
How?
Each year, when a new praetor took office, he'd publish his edict. This basically listed the legal actions, the remedies, the defenses he would grant during his year in charge, and over time, praetors tended to adopt the useful parts of previous edicts.
So it grew organically.
Exactly. It led to this body of law called the Emmius Honorarium, Praetorian law, which was more flexible, more responsive to changing needs than the really rigid old civil law. It's how Rome adapted its laws from governing a small city to running a vast empire.
And the key tool he used for this adaptation, this bridging of gaps, was the legal fiction.
Precisely. This is where Roman law gets really, really ingenious, and sometimes, frankly, a bit mind-bending.
Legal fictions. Let's unpack that. What exactly are they?
Okay, so a legal fiction is basically an assumption made by the law that something is true even though everyone knows it's not actually true.
A deliberate, acknowledged falsehood. Why do that?
To achieve a specific legal outcome that's considered fair or necessary. They were used to bridge the gap between that inflexible civil law and the demands of equity, or just new situations the old law never anticipated. The praetor's edict, or sometimes a specific statute, would introduce these fictions, telling everyone involved to proceed as if the fictional statement were true.
Okay, give us an example. The sources mentioned 3 really interesting ones. Let's start with this fiction of non-existence and the lex Aeschynia.
Right. The lex Aeschynia dealt with a particular class of freedmen, former slaves, who weren't full Roman citizens but were allowed to conduct business. The problem was how to fit their transactions into the existing legal framework.
So the law pretended it didn't exist.
Sort of. To make it work without disrupting the civil law categories, the lex Aeschynia itself stipulated that actions related to these freedmen's dealings should be handled as if the law granting them these rights hadn't even been passed.
That sounds completely contradictory.
It does, but it allowed obligations to be enforced. Gaius describes it very carefully. The obligation arises aer quodammodo peculiae, meaning in some fashion by the law of the peculium.
The peculium being.
A fund or property that a slave or a son under paternal power could manage. So by framing the freedman's obligations as if they were like a peculium, the law could handle them without giving the freedman full citizenship rights, which they didn't have. It let commerce function in this gray area.
Okay, that's complex. What about the next one? The fiction of death under the Lex Cornelia. This sounds even more dramatic. It deals with Roman citizens captured in war.
This addressed a really devastating legal black hole. Under Roman law, if a citizen was captured by the enemy, they suffered capitis diminutio maxima, the greatest loss of status. They legally ceased to be a citizen.
Instantly.
Instantly. They lost their family connections, their property rights, everything. And crucially, any will they had written became invalid the moment they were captured.
So if they died in captivity, or even if they eventually returned, their estate would be chaos, especially for wealthy families with complex arrangements.
Complete chaos. Intestacy. The Lex Cornelia was the fix. It decreed that the will of a citizen captured in war should be treated per inde, atque si in civitate decessisant.
Meaning?
Exactly as if they had died while still in citizenship. The fiction here is incredible. A living person, held captive, stripped of citizenship, was legally imagined to have died as a citizen at the moment of capture.
Just to make the will valid.
Just to make the will valid and protect the family's inheritance. The law basically told a necessary lie, treating a live non-citizen as a dead citizen because the social consequences of the truth were too disruptive.
That's quite something. Okay, third example. The actio ficta. Fictions about status, especially involving foreigners. Peregrini.
Right. This was a standard tool for the praetor dealing with the diverse population of the empire. If a foreigner was involved in a case, say, for theft, actio fruti, either as plaintiff or defendant, the formula for the legal action would often include a fiction.
What kind of fiction?
It might say something like, if it should appear that the defendant stole the item, if he were a Roman citizen, then condemn him. It fictitiously granted citizenship just for the purpose of that specific lawsuit.
So Roman procedures could be applied fairly.
Exactly. It brought the case under a standard Roman legal framework, and they used similar fictions, maybe even more technical ones, to protect creditors. Well, sometimes a person could undergo a change in legal status, like through certain types of marriage, coemptio, or adoption, aggregation, that under strict civil law could wipe out their existing debts.
A legal loophole to escape your creditors.
Potentially. So to prevent this, the courts could grant an action that included a fiction rescinding the capitis diminutio, the loss of status. For the purpose of that debt, the law pretended the status change never happened, preserving the creditor's claim. These fictions were absolutely vital tools for making Roman law work in practice.
It sounds like they were constantly trying to fit messy reality into neat legal boxes. But what happened when reality just wouldn't fit? When there was a genuinely new type of agreement or transaction that didn't have a name in the civil law, Ulpian apparently admitted this was a problem.
Oh, he had to. Ulpian famously said that reality has more types of transactions than names for them. The law simply couldn't anticipate every form of human ingenuity or economic exchange.
So what did they do then, when the standard legal actions, the named contracts like sale or hire, just didn't apply?
They had a fallback, a kind of catch-all remedy. The actio prescriptus verbis. This was an action based not on a standard contract name, but on the specific written-out facts of the agreement, the prescripta verba. It was the ultimate customizable lawsuit.
Flexible. But even within that flexibility, the Romans still tried to categorize things, didn't they? The sources mention 4 basic types of mutual obligation they used for these unnamed contracts.
Yes, even when dealing with the unnamed, the Roman legal mind sought structure. They broke down these reciprocal agreements, these situations where one person's performance was contingent on the others, into 4 basic patterns.
What were they?
First, I give that you give, do it does. Simple barter. I give you my wheat, you give me your wine.
Right forward. Second.
I give that you do it furches. This is interesting. I transfer ownership of something to you, and in return, you agree to perform some action. Like, I give you money or a slave, and you agree to paint my portrait, or maybe free another slave of mine. The giving triggers the obligation to do.
Okay. Third.
I do that you give, facio des. The reverse. I perform the service first, I paint the portrait, and then you are obligated to give me the agreed payment, whether it's money or property.
Makes sense. And the last one?
I do that you do, faciat facias, a mutual exchange of services. We agree to do things for each other. Maybe I agree to manage your farm for 6 months, and you agree to teach my son rhetoric.
That systematic attempt to categorize everything, even the unnamed stuff, really shows the Roman legal mind at work. It's such a contrast to Athens, where the focus felt more on the citizen, the performance, the honor. Roman law seems built on this intricate intellectual scaffolding fictions
It is
category.
all designed to manage reality and maintain order. But, and this is a huge but, when we shift from the theory and the cleverness of civil law to how criminal law was actually applied across the empire, especially later on,
That order looks very different depending on who you are.
radically different. The intellectual gymnastics give way to blunt social hierarchy. Hashtag tag tag 3, social status and unequal punishment in the Roman Empire. Yeah, this is where Roman justice can seem, well, deeply unfair by our standards. By the Severn Age, we're talking 2nd, 3rd centuries AD. The law wasn't just applied differently based on status, it explicitly codified that difference.
It was written down. Unequal punishment.
Absolutely. The jurists openly stated that not all can suffer the same penalties. There was a formal, recognized dual penalty system. It depended entirely on whether you were classed as honestiores or humiliores.
Okay, let's break that down. Honestiores, the more honorable ones. Who qualified? What happened if they committed a crime?
This group included senators, equestrians, the sort of knightly class, military veterans, and the curialis members of local city councils in the provinces. For these people, the punishments were overwhelmingly designed to avoid physical suffering or death.
So what did they face?
Mostly things like exile. There were two main forms. Deportatio, which was permanent banishment, often to a remote island and involved losing your citizenship and property, and relegatio, which was usually temporary exile, maybe to a specific place, but you kept your citizenship.
Still serious, but not execution.
Right. Or they might face modio ordine, being kicked out of the Senate or the local council, or just heavy fines. Actual execution, capi puniri, was incredibly rare for an honestior, reserved for the most serious crimes against the state, like treason.
Okay, now the other side, the humiliores, the more humble ones, the vast majority of the population, presumably.
Yep.
What was their fate?
The difference is stark and frankly horrifying. For humiliores, the standard severe penalties, the summum supplicium, were brutal and often designed for public spectacle.
Like what?
We're talking aggravated forms of death,
Yeah.
being thrown to wild beasts in the arena, bestiastari, crucifixion, crux, or being burned alive, vivis ori.
Just horrific. And if they weren't executed?
Then they face things like damnatio ad metalla, condemnation to the mines, essentially a life sentence of brutal hard labor, often ending in death anyway. Or opus publicum, forced labor on state projects like roads or aqueducts. The sheer physical severity was on a completely different level, purely because of their lower social status.
And this discrimination went beyond just sentencing, didn't it? What about things like torture?
Yes, torture had traditionally been reserved for slaves in legal investigations. But during this period, the 2nd and 3rd centuries, its use was extended. It became a standard tool applied to freeborn humiliores during the judicial process.
But not to omaxiores.
Generally not. Their status protected them from that kind of treatment. It also often protected them from pre-trial imprisonment. An honestior accused of a crime would usually remain at liberty until the trial.
While a humilior
Would likely be thrown in jail, often in harsh conditions, to await trial. Status bought physical comfort and dignity even before the verdict.
So high status meant not just a lighter sentence, but a whole different experience of the justice system. Better access, maybe?
Huge advantages. Honestiors often had their cases heard directly by the emperor or the senate in Rome, or by high-ranking governors in the provinces. These were venues where their influence, connections, and resources could really make a difference.
What about an ordinary provincial person who happened to be a Roman citizen but wasn't rich or influential? Did citizenship help them much?
Sometimes they might get their case transferred to a Roman court, but it wasn't always guaranteed and often wasn't even in their interest. Citizenship alone didn't give you clout. You needed connections. You needed money to travel to Rome, hire good lawyers. Without that, even as a citizen, you were often at the mercy of local justice, which could be arbitrary. Wealth and connections were the real keys.
Knowing this makes some of the earlier arguments about punishment, like from the Republic, seem well layered. Take Cicero defending Rabirius. He talks about humane treatment, humanitas. How did that fit into this tough system?
Cicero's defense of Rabirius back in 63 BC is a brilliant piece of rhetoric, but you have to read between the lines. Rabirius was on trial decades later for helping put down a populist tribune, Saturninus. Cicero argues for humanitas, for leniency.
But why? On what grounds?
Not because Rabirius had an inherent right to humane treatment. Cicero explicitly links it to re publicae utilitas, the interest of the state. His argument is essentially, Rabirius acted in the state's interest all those years ago by suppressing Saturninus, therefore the state should show him humanitas now.
So mercy was conditional on political expediency.
Entirely. If Rabirius had been deemed an enemy of the state, you can bet Cicero would have been demanding the harshest penalty. It shows that these appeals to humane ideals were often political tools, not fixed moral principles.
It's hard then to find real consistent voices against capital punishment in Rome, despite speeches like Cicero's.
Very hard. Cicero certainly wasn't an abolitionist. Maybe the closest we get is Julius Caesar during the debates about the Catalan conspirators. He argued against executing them, but mostly on practical grounds, warning about setting a dangerous precedent, not really on moral ones.
And later on, the jurists who actually wrote down the rules for the dual penalty system, they just described it. No judgment.
None whatsoever. They meticulously categorized who got thrown to the beasts and who got exiled, but with this chillingly detached bureaucratic tone. No hint of moral outrage about the fundamental unfairness of it all.
So Roman law, for all its sophistication with fictions and categories, ultimately served to reinforce the existing social hierarchy, sometimes through cleverness, but often just through brute codified inequality.
That seems fair. And when these legal systems, whether the Athenian or the Roman one, collided head-on with political chaos or military demands, the law often just buckled. #5-5. Legal failure and political military intrusion.
Yeah, the integrity of the legal system, its ability to function, was completely dependent on the stability and integrity of the political and military structures around it. When those failed, the law often failed too.
We see that really clearly in the late Empire, right? The sources mention this case involving Count Romanus in Tripolitania, North Africa. It links military corruption directly to a breakdown of control.
It's a stark example. The narrative explicitly blames the loss of Roman authority outside the main cities on the Roman soldiers themselves, their inertness and their greed to seize upon other people's property.
So the army wasn't protecting the province, it was preying on it.
Under commanders like Romanus, yes, he's described as the worst. He neglected his duties, apparently took bribes, and essentially let the security situation deteriorate while enriching himself and his troops. The defenders became the problem. So the legal failure here wasn't about bad laws, but about a complete collapse of enforcement and integrity at the top, which led to actual loss of territory.
Exactly. The corruption within the military command structure directly enabled the breakdown of Roman law and order, making the frontiers vulnerable. It shows that even the best legal code is useless if the people meant to enforce it are corrupt. The system failed from within.
Let's switch back to Greece for a different kind of failure. Not corruption, but maybe strategic failure. When vengeance overrides pragmatism. The incident after the Theban attack on Plataea during the Peloponnesian War.
Right. The Thebans made a surprise attack on Plataea, Athens' ally. The Plataeans managed to capture a number of the Theban attackers.
And Athens sent a message.
They did. They sent a herald telling the Plataeans, basically, hold on, don't do anything rash with the prisoners until you consult with us. Pericles, the Athenian leader, apparently feared the Plataeans would kill them immediately.
And he was right.
He was right. The Plataeans, probably driven by anger and fear after the attack, executed all the captives before the Athenian message could properly sink in, or maybe even before it arrived.
And this was seen as a mistake.
A glaring impolicy, according to the source. Why? Because among the dead Theban prisoners were several important figures, men of high rank.
Hostages, basically. Bargaining chips.
Potentially very valuable ones. They could have been exchanged for captured Plataeans or Athenians, or used to negotiate concessions from Thebes. Killing them brought immediate satisfaction, maybe, but it threw away significant strategic leverage.
So the immediate desire for vengeance, perhaps understandable, conflicted with the longer-term political interests of the war effort.
Precisely. It's a classic example of how raw emotion or localized justice can clash with broader state strategy, especially in wartime. The Plataeans acted on the old law of retribution, perhaps, ignoring the new calculus of power politics within the Athenian alliance.
It's a reminder that sometimes restraint or clemency isn't about morality, but about cold, hard calculation.
Absolutely. And when you get to the very top, to absolute rulers, sometimes even calculation seems to disappear, replaced by pure personal will and wrath.
You're thinking of Xerxes, the Persian king.
The anecdote about Xerxes and Pythias is chilling. Pythias was supposedly the richest man in the entire Persian Empire, incredibly wealthy. He hosted Xerxes and his entire massive army before they crossed the Hellespont to invade Greece.
So he showed extreme loyalty and generosity.
Immense generosity. As the army was preparing to leave, Pythias made just one request. He had 5 sons, all serving in the army. He asked Xerxes if his eldest son could be allowed to stay behind, maybe to manage the family affairs.
Seems like a reasonable request, given his contribution.
You might think so, but Xerxes' reaction was extreme. Boundless wrath, the source says.
What did he do?
He ordered the eldest son, the one Pythias asked to keep back, to be seized, killed, and his body cut in 2.
What?
And then he had one half of the body placed on the right side of the road leading out of Sardis and the other half on the left. The entire Persian army then marched out between the 2 halves of the corpse.
My God, as a warning.
An absolutely terrifying theatrical warning. This wasn't law, it wasn't even strategy. It was pure, absolute power demonstrating that military service was non-negotiable. No amount of wealth, status, or prior favor could exempt you or your family. It was Xerxes' will made brutally manifest.
It really drives home that in these ancient systems, especially autocratic ones, the law could just evaporate in the face of the ruler's immediate demands or anger, particularly concerning military discipline.
Okay, so let's try to pull these threads together. We started in Athens, seeing their courts as these highly competitive spaces driven by feuds, citizen initiative, and this constant striving for honor, for philotimia.
Right, and we saw their culture through tragedy like Aeschylus, grappling with the idea that even formal civic law couldn't fully escape the weight of the past, of inherited guilt or destiny. Then we shifted to Rome, with its incredibly formal, structured legal system, masters of the legal fiction, using these clever constructs to make rigid laws work for a sprawling, complex empire.
But that same system simultaneously relied on this brutal, explicit inequality, the dual penalty structure. Your fate in court depended almost entirely on whether you were an honestior or a humilior. Justice was nakedly class-based.
And woven through both cultures was this recurring theme. When politics or military needs pressed hard, whether it was Romanus' corruption undermining defense, the Plataeans choosing vengeance over strategy, or Xerxes enforcing discipline, the abstract ideals of justice often took a back seat.
Definitely. The law, at the end of the day, often served the interests of the powerful, the state, the military. Whether that power was exercised through rhetorical skill in an Athenian assembly, or through codified social privilege in Rome, or through the sheer autocratic will of a king.
Even their philosophical reflections, like in Aeschylus, acknowledged these deep limits on human control, on escaping the consequences of the past.
That's a really key takeaway. The limits of law, the limits of human agency.
We spent a fair bit of time on those Roman legal fictions, how they deliberately pretended things were true, like a captive being dead or a foreigner being a citizen, just to make the system function, to smooth over reality's rough edges. Which leads me to a final thought, something for you, the listener, to maybe ponder. How much do our own modern legal systems, which we often think of as so rational and rigid, still rely on unspoken, maybe unacknowledged fictions? Think about it. Corporations treated as persons, complex financial instruments given legal standing, old precedents applied to radically new situations. Are these just the modern equivalents of Roman fictions? Necessary constructs we accept to keep the system running, but which future generations might look back on as, well, just as strange as pretending a live captive was legally dead. What are the fictions we live by today?